Good afternoon, and thank you for joining Venable's presentation on Loper Bright, Jarkesy, Corner Post, and Cantero, reconciling the Supreme Court's overhaul of agency action in the financial services industry. My name is Andrew Bigart, and I'm co-chair of Venable's Financial Services Group. I'll be moderating what should be a great panel by some of my colleagues from the Financial Services and Litigations Group today. It's not often that the legal intricacies of administrative law receive front page attention, but that has certainly been the case the past several weeks with several of the Supreme Court's cases that have been announced. Our goal today is to provide an overview of those decisions, but more importantly, we hope to provide context and practical commentary that will hopefully help you understand the potential implications for your industry and business. And in addition to getting to nerd out with us on administrative law, you get the bonus of CLE credits, and we will provide those codes throughout the presentation. Let me briefly introduce today's speakers. Adrienne Gurley is a white-collar defense partner in our Los Angeles office who represents companies in investigations and enforcement actions in front of the SEC, the Department of Justice, and many other agencies. Liz Rinehart is a partner in our commercial litigation group who represents clients in class actions, commercial litigation, but also a number of regulatory investigation matters, particularly involving the Federal Trade Commission and the CFPB. Max Bonici is a counsel in our financial services group who counsels U.S. and non-U.S. banks and other financial institutions on regulatory, supervisory, and enforcement matters. David McGee and Chelsie Rimel are associates in our financial services group. They work with Max and I closely and others in the group on state and federal regulatory compliance and enforcement matters. And finally, Liz Sines is an associate in our commercial litigation group who also works on a number of state and federal matters. As a very kind of broad interview, we're going to look at these four Supreme Court decisions that you can see in the slide in front of you and talk about how they can impact a number of important topics, starting with kind of litigation and agency action, agency enforcement, the agency rulemaking process, and other practical considerations. If possible, at the end, if there's time for questions, we're happy to take those, and you should be able to enter those into the system so that we can see them. Our initial sense, I think, and we'll see how the panelists discuss today, but that we may see increases in challenges to agency action, increased judicial scrutiny. We may see the agencies adjust in other ways, such as by shifting towards enforcement rather than rulemaking as a result of these recent administrative developments. And while these are very important cases, it's not the first time that these agencies have had to react to changes in law or judicial interpretation. And generally in the past, they've been pretty nimble in finding new ways to carry out their goals and responsibilities. And from the congressional side, we'll likely see Congress also providing some more specificity when they issue statutes. So those are the types of topics we're going to get to. But before we can do that, I think we need to have a little bit of background on what these cases are. So let's get started with Loper Bright, the case that has probably attracted the most attention and which may have the biggest impact. And for that, I'm going to turn it over to our colleague, Liz Sines, who can kick it off with a brief overview of that case for us.
Great. Thank you, Andrew. So jumping right in, let's talk about Loper Bright. Loper Bright and its companion case, Relentless v. Department of Commerce, began as a challenge to an agency rule relating to the fishing industry. But it quickly became a vehicle to challenge the concept of Chevron deference. So what is Chevron deference? Chevron deference is a legal doctrine arising out of a 1984 decision in a case called Chevron USA v. Natural Resources Defense Council. And this legal doctrine required a court to defer to an agency's interpretation of a statute if the interpretation is permissible. In Loper Bright, in an opinion written by Chief Justice Roberts, the Supreme Court struck down Chevron deference and held that deference to an agency's interpretation of a statute is contrary to the Administrative Procedure Act and contrary to the judiciary's responsibility to both interpret statutes and decide questions of law. The Supreme Court found that Chevron could not be squared with the APA because the APA requires courts, not agencies, to decide questions of law and statutory interpretation. The court explained that the doctrine of stare decisis did not prevent them from overruling Chevron because the Chevron doctrine had proved to be unworkable, arbitrary, and inconsistent. Still, to be clear, the court was explicit that Loper Bright does not overrule decisions applying the Chevron doctrine. Holdings of cases finding that specific agency actions are lawful are still considered precedent, despite the change in interpretive methodology. Ultimately, Loper Bright established that courts can still consider an agency's interpretation along with other sources of expertise and guidance, such as amici, but courts cannot ignore traditional methods of statutory interpretation in favor of determining whether an agency's interpretation is permissible. Courts may also not assume that statutory ambiguity was Congress's implicit delegation of authority or discretion to an agency. Ambiguity may be the result of any number of other reasons, like Congress being unable to resolve an issue or maybe failing to consider it. But neither situation is an express call for deference to an agency. Congress can delegate discretion to an agency subject to constitutional limits, but they must do so explicitly. And in separate concurrences, Justices Thomas and Gorsuch emphasized that Chevron deference was an unconstitutional violation of the separation of powers between the executive and judicial branches. And in the dissent, drafted by Justice Kagan and joined by Justices Sotomayor and Jackson, those justices criticized the decision and argued that the Chevron doctrine was entitled to a particularly strong form of stare decisis because Congress has never repudiated the doctrine and courts and litigants have relied on it in thousands of cases.
Thank you for that, Liz. And with that, we can move on. Adrienne, I think you're going to walk us through the Jarkesy case.
Sure. So the Jarkesy case first started in 2013 when the SEC brought a cease and desist proceeding against Jarkesy and a few other defendants and his firm, Patriot 28. And they brought it in the ALJ forum seeking civil penalties. And it was a case involving securities laws violations. And in that case, the ALJ found him liable and ordered that he pay a civil penalty. And from there was an internal appeal, an appeal to the Fifth Circuit, and eventually it ended up before the Supreme Court. And so with the Jarkesy decision, we have a decades-long challenge that was finally decided just on June 27th. And the court there found that when the SEC is seeking civil monetary penalties against a defendant for a case involving fraud, the Seventh Amendment entitles that person to a jury trial. And so basically the Seventh Amendment says if a citizen is being accused or there's a civil claim exceeding $20 against that defendant, they have the right to a jury trial. So that's basically any civil case, any civil monetary case that could be brought against someone. So the SEC can't, in these sorts of matters, rely on its in-house ALJs to decide fraud cases. And so that was what the court focused on. There were other constitutional issues that Jarkesy brought before the case. The Supreme Court declined to rule on those areas. And so this case specifically involves the seeking of civil monetary penalties. And one of the things to note is that part of the court's reasoning was that because the SEC's fraud cases were akin to common law fraud charges where civil monetary penalties are quote unquote prototypical common law remedies, that's meant to punish and deter. And that's what the court looked at in a case where the remedy is meant to punish and deter rather than cure some public right. That's the exception. And so the takeaway is that if the SEC is seeking civil penalties and it's attached to something that can be seen within the common law or handled within the common law, they have to go before the district court, not an ALJ, because citizens have a right to a jury trial in those sorts of matters. And so that's the Jarkesy case in a nutshell.
That's great. Thank you for that. And so we can move on to the third of the cases, which is the corner post case. And Chelsie, I think you're going to be walking us through what that one's all about.
Thank you, Andrew. So corner post was one of the last decisions to come down in this momentous Supreme Court term. And while it's not as flashy as Loper Bright, this deals with the statute of limitations, it's still noteworthy. So corner post is a truck stop in North Dakota that first opened in 2018. And the rule at issue here is a 2011 Fed rule concerning interchange fees for debit cards. So these are fees paid by businesses to banks when customers use debit cards for purchases. And this 2011 rule capped these fees at a certain amount. In 2021, Corner Post brought this suit against the Fed, saying that this rule permits higher fees than the Durbin Amendment to the Dodd-Frank Act allows. Now, traditionally, there's a 6-year statute of limitations for APA challenges to the regulations. So the Fed argued that this began once the rule was finalized in 2011 and then expired 6 years later in 2017. So the Fed said, Corner Post, you're too late, you're out of luck. And the District Court and the Eighth Circuit agreed with the Fed. However, as we know, the Supreme Court did not. The Supreme Court said that the statute of limitations does not apply until a plaintiff is injured by a final agency action, and that the statute of limitations is accrual-based, and a cause of action does not accrue until a plaintiff can file suit and obtain relief. Now, it is important to note that the majority opinion emphasized that this has to be a final agency action, and that this is not limited to just rulemaking, but it can be any agency undertaking that harms a party. And Congress may specify other statute of limitations and how they run, but unless and until then, this is the rule. So bottom line, the 6-year statute of limitations does not start to run until a plaintiff is injured. This is a very plaintiff-centric rule. Now, the dissent warns of a tsunami of litigation where plaintiffs can challenge rules that were finalized decades ago. And this decision, coupled with Loper Bright, has raised those concerns in the legal community, which we will discuss shortly. But before then, I'm going to turn it back over to Andrew to introduce our final case.
Great, thank you, Chelsie. And so with that, David, I think you're closing out here on the case discussions and overview. So walk us through the Cantero case.
I am. Thank you, Andrew. Happy to be here today talking about Cantero. So a little bit before all these other Supreme Court cases we just discussed, May of this year, the Supreme Court comes out with this decision in Cantero, really focused on the National Bank Act and preemption under state law or under federal law of state laws applying to national banks. So the main thrust of Cantero is that the National Bank Act does not enjoy field preemption over the field that it regulates, i.e. state laws may still apply to national banks, even though that there is a National Bank Act. Interestingly, by statute, the Dodd-Frank Act provides a framework for this analysis, which generally traces along Barnett Bank v. Marion County, and whether a law discriminates against national banks as compared to state banks, or prevents or significantly interferes with the exercise by the national bank of its powers in accordance with the standard under Barnett Bank. So, in analyzing the New York mortgage interest escrow account law at issue, the Supreme Court basically said that it depends. It depends on whether a state law will prevent or significantly interfere with the exercise of a national bank's powers, and invited us all to do a little homework and rereading the Supreme Court's cases dealing with that issue. So I think the bottom line here is that for national banks and others under the National Bank Act, a preemption analysis is going to have to be done for laws that are not, explicitly limiting the powers of a national bank, which the Supreme Court did not choose to define in their holding in Cantero. So what that means is for any state law that may or may not be preempted, the bank's going to have to look at it, determine under Barnett Bank whether it is preempted, and if so, they don't have to follow it. But if they do, then they're going to have to comply with the state law. So this is an interesting kind of point of in terms of Loper Bright, Corner Post, Jarkesy, is an interesting kind of application of the courts taking more ownership over, regulations and areas of kind of agency interpretation. So with that, I think we've laid the groundwork here, Andrew, so I will turn it back over to you.
Great, thank you. And I think, the benefit of those quick case digests is that we've saved the audience having to read hundreds of pages of Supreme Court decisions. So hopefully that gives you a good background as we start talking through what some of the real world implications of that might be. And so now with that background, let's really start diving into some of what this means in practice in the financial institution space, but even more broadly. And Liz Rinehart, I know that you've been watching Loper and following all of these cases, pretty closely. And so with your litigator hat on, what are the types of issues that we should be thinking about, that companies in the space should be thinking about, and what do you expect kind of moving forward?
Thanks, Andrew. And I know I don't like to quibble with my host when he's doing such a good job, but I think we've stolen the opportunity of the audience to read hundreds of pages. It's summer, it's hot. Why not sit inside in the air conditioning and read about administrative law? That's my pitch. So how are courts responding? Well, not surprising to anyone, many of the courts are simply saying, I want to read more briefing. I want to hear about how the parties think that these cases should be interpreted, whether they're even relevant. I think it's kind of the kick the can down the road, but at the same time, I don't want to be reversed either. And now that there's much more power and much more scrutiny that's supposed to be wielded by the judiciary, I think courts just want to have a better understanding, and they're asking litigants to help. And so that represents both an additional burden, but also a great opportunity for litigants. In the appellate space, we've already seen just vacating district court opinions and remanding back to the district court in order to reassess in light of these new cases, which is basically a similar response, right? Like, we want more time, we want more information. And so we're giving everybody an opportunity to try again. We have seen appellate courts simply undertake the de novo statutory analysis that Loper Bright is calling for, looking at the statute, saying this is how we interpret it, and then making a call based on that interpretation. And similarly, we've seen courts apply what Loper Bright is asking us to do, which is, you don't have to defer to the agency's reasoning, but if it is persuasive, you can take it into account, similar to a Skidmore deference, which the court explicitly referenced, and as far as we know for right now, is still an option for courts who are making these decisions. So really the full spectrum, everything from we're going to put it into action to we want to see how this works out and we want help from the litigants. Oh, you're muted, Andrew.
There you go. Thank you. Always looking out for me, Liz. Along those lines, are there, what do you see in terms of, as we've got on the screen here, kind of the process for amicus, others that are interested in the case, and, some of the practical aspects of how do you bring litigation and challenge these types of issues?
So I definitely think there is enhanced opportunity for amicus briefing. I think that courts are going to be looking for experience, expertise outside of the agency so that the courts themselves can't be accused of being overly deferential to the agency. And one way to do that is to ask for outside neutral or slightly not neutral, but not parties to bring to bear their expertise on factual issues so that the court can say, not only did I consider this from the agency, but I also received briefing and I've weighed all of it and this is my decision. And I think people may be surprised to hear that because obviously Chevron and Loper Bright were talking about legal interpretations. That's part of the fundamental reasoning behind Loper Bright, is that courts should be engaging in this analysis because the courts are the experts in the law. But I still think amicus have a role to play, and they can just simply provide a little bit more security and persuasion behind a court's interpretation of the statute. So I really think that there's going to be a lot of opportunities for amicus briefing, and that's going to sort of feed very well into some of the recommendations I think we're going to make in this webinar, that it's going to be important for anyone in this industry to continue following litigation as it develops, to see if there's an opportunity to weigh in or to form a coalition that then weighs in. In terms of affirmative challenges, I do think we're probably going to see an increase. The question is how much. I think along with those affirmative challenges to agency actions, we're going to see a lot of forum shopping and then subsequent circuit splits. So people are going to be looking for circuits that are either hostile to agency actions, and I think we all know what the #1 circuit is if you want to have an agency action struck down, versus if they're, for instance, looking for someone who may be in favor of an agency action, they may go towards a circuit that's much more friendly and deferential. Similarly, coalition litigation, I think we're going to see an increase in that as well. So certain industry actors getting together in order to do more of like deferring, spreading the cost around. Affirmative challenges are expensive. They are also risky. The minute you step forward and say that you want to challenge an agency action, you have the potential to sort of bring that spotlight to your attention. And then I'm going to say a little bit about enforcement, but then I think I'm going to pass along to Adrienne if she wanted to speak. I know she wants to speak a little bit more on enforcement. I don't want to get too far over my skis. I think that the fact that fact-finding still enjoys deference, to me, is going to lead to increased enforcement to the extent agencies have the manpower and the sort of appetite to engage in enforcement as opposed to rulemaking. I know that the CFPB, sorry, I'm laughing because I just got a great question. I apologize. I'll pause right here. It's the Fifth Circuit. The Fifth Circuit is the circuit you want to go to if you're looking for an agency or for a circuit that is hostile to agency actions. Adrienne's smiling. It's, you know, unless things change, that's really where people want to go. Because fact-finding enjoys deference, I think you'll see enforcement actions increase, or at least become more of a vehicle for the types of agency actions that would normally be rulemaking and even more policy making. But if the agency is able to identify a particular actor that they can, for lack of a better term, use to prove a point, then bringing an enforcement action as opposed to rulemaking, they get the benefit of that deference to their fact finding. And they get the benefit of, for lack, again, of a better term, being able to use what may be a really terrible actor in the industry. And that is not to make a broad point about enforcement, but the agency could find someone behaving pretty poorly. And that's just going to increase the persuasiveness of the agency's interpretation of what they are doing and the, you know, just general atmospherics of what the agency is asking the court to hold. I think along with enforcement, whenever enforcement increases, I think you're going to find a bigger appetite for preemptive challenges. We saw Axon in the previous term, which kind of emboldened people to think about ways to mount collateral challenges to enforcement actions. That includes that case considered the Thunder Basin line of cases. I think we may see a little bit more of that if enforcement creeps up. And with that, I'm going to stop talking and let Adrienne weigh in.
Yes.
Thanks, Liz.
Take it away, Adrienne.
Thanks. So specific to enforcement, you know, the enforcement is really the way that the SEC sends its messaging, right? You have the 33, the 34 Acts and the 40 Acts, and that's from 1933, 34, and 40. So the case law, not the case law, the statutory authority has been established. It's been well established. And so I don't see that the SEC is necessarily going to try to relitigate what's already been established, right? But the enforcement is the way that the SEC can send a message to deter people from engaging in certain violations of the criminal, not criminal, of the SEC's, the securities laws, right? And so I think that rather than rulemaking is what we'll see them to continue doing. It's questionable whether or not the Jarkesy decision is likely to impact the decision making on what cases to litigate. And I say that only because the SEC is comprised, the enforcement division has its investigative attorneys and it has its trial attorneys. And so the trial unit is very, well versed in taking cases to district court and filing actions against defendants. And so they're already used to being in federal court. And they've also dealt with this before. There was a Lucia case that was pending. And so for some time, all administrative law cases were stayed. And so again, like litigation is something that the SEC is used to. And so with that, though, I think the calculus will be whether or not it's worth litigating, right? If you have a case that may create bad case law for the agency, much, Liz, in the same way you mentioned, judges not wanting to be overruled, there may be, some considerations taken into whether or not to litigate a case or seek some sort of other alternative, such as settlement. But again, because the SEC is so used to litigating, I don't see a difference in how they would go about being in federal court. I think where the Jarkesy decision has wider reaching impact is for other agencies that have ALJs and don't have the option to go to federal court. And so for one, what's the rulemaking going to look like for those agencies where they don't already have the option to go to district court like the SEC does? But then also just what are the attorneys at these agencies who aren't used to going to district court now going to do? There's like a level of training that may occur because they're just not used to going to district court. And so again, to the litigation side, I think for the SEC at least, that it's something that they're used to.
That's great. And I mean, obviously, there's a lot of, the Supreme Court comes out with decisions regularly that can have impact on the administrative process, and especially when it comes to enforcement sometimes. And so, Liz Rinehart, I mean, we've seen in the past agencies have challenges because of maybe a new case that comes out that limits what they can do on the enforcement side. I'm thinking like the FTC in particular recently. I mean, how have we seen just kind of historically some of these agencies respond? I mean, Adrienne was talking, the SEC is kind of maybe already in a good spot, but how have other agencies kind of responded in the past to these kind of developments?
Andrew, that's a great question. And, I think it's important to note, which the slide already does, the CFPB as well has really already moved many actions to district court. I mean, when we see the CFPB bringing administrative actions, it's typically not the type of adversarial fact-finding engagements. They've already moved that to the district court. And I think that's, not to, put thoughts into their head, but I think that might have been a response to all of the challenges that their agency was facing, not just with funding, but also with the constitutionality of many of their administrative procedures. There are weaknesses there for the agency. And so I don't think it's surprising that they usually elect, when they have kind of these like linchpin cases or these cases where they're going to be closely scrutinized, to just bring those in district court. I mean, much like Adrienne mentioned, there are resource issues for the agencies. No one wants to go through an entire adversarial administrative proceeding and then have a district court come in and reverse. So that I think is an interesting way in which we will see changes, but it may not affect every single agency the same way. Similarly, the thing I was thinking about while you were asking the question is, we've seen the FTC pivot rather gracefully after the AMG case, which people may recall limited the agency's ability to obtain consumer redress in certain situations that could be their own webinar. What you ended up seeing is the agency invoke other authority. You saw them start issuing notices to individuals of certain practices that the agency considered deceptive. which the agency could then use in order to bring cases under other statutes, because now the individuals were on notice. You also saw a lot of coordination with state AGs. And I think that's something I don't want anybody to sleep on here. While we will spend a lot of time in this webinar, and it is very important to follow federal agency actions, there are a number of state AGs that they have their Wheaties for breakfast, and they want to fill in the blanks. They want to fill in what they're seeing is a weakening of the federal administrative enforcement state. I can think of a few states, but again, that's a whole other webinar. And I think it also depends on which issues we're talking about. But state law varies greatly, and the amount of enforcement power that a state AG may have and the theories that they have to bring cases under could be very different. And so very similar to following circuits for circuit splits, I think the industry is going to need to follow state AGs as well and see how those cases are developing throughout the country.
Great. Thank you. And I think now we're about halfway through, so it's a good time to give a CLE code announcement. And so the CLE for today's presentation is Agency 2024. That's Agency 2024, all one word. And we will give that back at the end of the presentation as well. So I think, we've kind of covered a lot of the, I don't want to say basic because they're not basic, but we've covered a lot of the initial litigation and agency enforcement issues that I think come to mind immediately. But maybe if we shift a little bit to the litigation 201 level, one of the things about administrative law and litigation in that space is that there's a lot of other issues that need to be taken into account. All of these cases, you really can't just consider the concept addressed in isolation, right? There are other pieces that kind of fit the puzzle. And I think you can see some of these on the slide here. So I don't know, Liz or Adrienne, who wants to kind of jump in, but maybe walk us through what some of these other kind of related issues are, what are kind of some longer term predictions and issues you might see.
So I can take this one, at least to start. And some of these are maybe even more my wishful thinking because I think they're fascinating topics. But I think we're going to see an increase in constitutional challenges. I think that people have picked up on an appetite of this court to reinvigorate some specific doctrines and frameworks that many people thought were just dead on arrival. I'm thinking specifically about non-delegation, which it used to be you'd be a laughingstock if you suggested bringing a non-delegation challenge. And I will pause here sort of to differentiate because I think there's a lot of uncertainty and a lot of sort of new to you-ness about the major questions doctrine and non-delegation and statutory interpretation and how the three of those may interact. So major questions sort of first came into the legal press, at least the wide-ranging out of academia, we'll say, in the last term with the West Virginia EPA case where the Supreme Court sort of enshrined it into our case law that basically Congress doesn't hide authority. If Congress wants an agency to do something, Congress will say it, and it will say it explicitly. And courts are not to go looking under every nook and cranny and every rock we can find for an explanation or for support for an agency's assertion of authority. I sort of describe major questions as agencies don't get to be creative. And that's a problem now because we are taking away Chevron, we're taking away a very powerful tool that agencies had in order to see their agendas effectuated and in order to assert jurisdiction, particularly in enforcement actions that maybe isn't clear on the face of their statute that they even have. So major questions is going to be something to watch if agencies try to respond to Loper Bright and the related cases by finding new and creative ways to assert their powers. Non-delegation is slightly different, but similar. In non-delegation, what we're really looking for is whether Congress has explained discrete principles of how agencies are supposed to put into effect their statutory mandates. So, for example, if Congress says to an agency, create this limitation, create this rule. And it's very specific. We want you, and I'm well over my skis with environmental law, but I think it's a good example. Create emission standards for cars that have 4 wheels and weigh over 2 tons. I have no idea if any of those numbers make sense. That's a very specific command that Congress is giving the agency. There really couldn't be much of an argument that Congress has abdicated its role as the legislative body. And that's what non-delegation is looking for. It's looking for whether Congress has given enough guidance to an agency that the agency is not engaging in sort of like doing Congress's job. And that, you can probably imagine, becomes a very squishy, complicated analysis. And for a long time, no one worried about it because you just didn't win when you made the argument. But I think we're going to be seeing that here because, the flip side of Loper Bright is that if the agency has been given a specific command by Congress, then the statute isn't ambiguous. And so that may be what we see agencies arguing when they're faced with a challenge that they shouldn't be entitled to deference. And then the last one there just sort of fits in with the amici, right? I think we're going to see courts turning to experts more often in many of these cases for enforcement, just to get that additional sort of oomph to whatever they're deciding, particularly if what they're deciding is for the agency and they don't want to be accused of excessive deference.
Great. And I know that we said we were only going to focus on these 4 key cases, but just as I think as a reminder to everyone, there are obviously cases happening all the time that impact the administrative process. And so we've got 2 here that happened also within the last year. And so Liz, is this on your plate as well to maybe just kind of quickly give us an overview of what these 2 cases stand for?
I certainly can, but obviously if anyone else wants to chime in, I don't want to have all the fun here. So really quickly, Ohio versus EPA, I want to see how this case is applied only because, I personally bear the battle scars of making arbitrary and capricious challenges in court. You typically are just running right into a buzzsaw because the standard is so high and agencies know how to build up a record to support what they're doing. For those that aren't as familiar, basically, a court will uphold a decision, particularly a fact-based decision, by an agency, so long as it is not arbitrary and capricious, which you can imagine how sort of, you would think off the wall a decision would have to be. My personal feeling is that the arbitrary and capricious standard is subject to a lot of ideological shenanigans or sort of bents than when you have a court who just doesn't like what the agency did, but that's neither here nor there. So here, this was one of the rare cases where the court found that an agency action was arbitrary and capricious. As I think I've mentioned enough, I am not an environmental lawyer, so I'm not going to get into much more about what the Clean Air Act rule was, but basically the agency had come up with an assumption and had not explained why that assumption was still correct, even if other assumptions were not true. So basically, the court found that the agency didn't explain itself. How this case is going to be used moving forward is going to be quite fascinating to me. If it ends up kind of chipping away at the arbitrary and capricious standard, that's just simply another vehicle for challenging agency actions. And then National Rifle Association, also very fascinating to me, involving really insurance law and what I would sort of roughly characterize as the discretion of an agency to bring enforcement action. So here, I believe you had an agency in New York who basically told various insurance companies that they would be under increased risk of an enforcement action if they worked with the NRA. And basically the court said that that was violative of the First Amendment, at least on the motion to dismiss ground. And I think that's important to note, right? Like in this case, we are talking about a pleading stage. So how the case ends up, we'll have to follow it. The other thing I thought was really interesting about the NRA case is that there was really no dispute that what the insurance company was doing was illegal. They were violating, the law in that case, but it didn't matter. Simply saying you're going to be targeted because of your working with this certain organization, was considered to be discrimination, or excuse me, suppression of speech based on an ideological viewpoint.
Thank you for that, Liz. And Max, Liz talked a little bit about non-delegation doctrine and delegation type issues, but I think we ought to dive into that a little bit more, in particular, kind of some of the examples we have here, but also really in the context of the financial services industry and the banking industry and how delegation can play there. And can you walk us through that some?
Sure. Thanks, Andrew. Just to pick up where Liz left off, that it was an interesting case. It was the last NRA case because it involved the New York DFS, near and dear to many in the financial services space. And you could see kind of the ripple effect on how that would work, and how some other agencies have used their enforcement or supervisory powers in the past. And that is why, when thinking of statutory delegations, why we think for financial services, there's been a lot of hype post Chevron and these other cases. But maybe that's exciting for other regulated industries, but we think that people in the financial services space should pump the brakes a little bit and not buy into all the hype, because in many ways, Congress looks to these regulators, the federal financial regulators and others, pretty clearly in statute. We've given you an example here of the Truth in Lending Act, just to show you in the case of something like the CFPB, it calls the statute calls for the promulgation of regulations by the CFPB, as in that are in the judgment of the Bureau, the CFPB, to be necessary or proper, to effectuate the purpose of the statute, the Truth in Lending Act, to prevent circumvention or evasion of it, to facilitate compliance with it. That doesn't mean that the agency can do whatever it wants to. It doesn't mean it won't be challenged. But in this case, this is an emblematic example of Congress looking to these federal regulators and saying, this is in your area of expertise. Implement rules for this industry. We see it in Dodd-Frank. We see it in all sorts of banking statutes that call for whether it's safety or safety and soundness provisions, guidelines, things like that. And this is very much predicated on the fact that, at least for the federal banking agencies, and to some extent the Bureau, the CFPB, they have supervisory powers. This is markedly different than other regulated industries. Other regulated industries don't have necessarily their regulator coming in, using visitorial powers and combing through their books and records, scrutinizing their decisions to the level of detail that the federal banking agencies and the CFPB can do. There are others might have disclosure regimes. They may have very, very prescriptive regulation, but in this case, there's another that supervisory layer. Plus, in many cases, Congress saying, especially after something like the financial crisis, where they said, okay, we gotta the 2008 financial crisis, we gotta clean up. We need a new regulatory framework. We need to change the regulatory perimeter. Now we're calling for rules to do so. So this is very different. I'd like to invite Adrienne and Liz to discuss how that might be a little different for the SEC, or maybe even what the contours are, even with these clear statutory delegations. For Liz, I know for Adrienne, the SEC is a completely different regime, and Liz, this isn't a free pass for the agencies, kind of a backdoor to Chevron deference again, right?
I think you're right. Again, with the SEC, there's already pretty well established rules already in place, et cetera. And so, part of it is that there has to be some level of deference given to the SEC, just because the SEC understands in theory, right, what their rules mean. And every year the SEC comes out with their exam priorities, and then they report on their enforcement wins, losses, et cetera, their enforcement numbers for the prior fiscal year. And so that is where I think those of us outside of the SEC should focus our efforts. Like, what are they saying? What are they telling us? Because they'll tell us what it is that they're going to focus on each year. And then we can then on this side, form our, compliance departments, et cetera. We can figure out how to fit within the realms of what already exists so that we stay out of trouble and, that the SEC can't come knocking, so to speak. But I don't necessarily see much of a change in what's already been established. But there are areas where, and I hope I'm answering your question, but there are areas where, with the unwinding of the Chevron deference, there will be challenges to the SEC's interpretation because it's the SEC's interpretation of their statutes. That's how they enforce them, right? Even as far as offering frauds, like how do we bring an offering fraud? And determining what's a security and how we test and all those things, like that is really within the crux of what the SEC does. And so specific to the SEC, I do think paying attention to what's been done in the past is what's going to help us on this side of things move forward.
I think just to add a little bit on to what Adrienne was saying there, and also some of what Max was saying, it's all well and good to talk about these cases in the abstract and how you can litigate and challenge them. But if you're a regulated entity, whether it's SEC or a bank, for example, and you've got examiners that have supervisory authority, you're going to get a lot of guidance from them as to what they expect you to do. And you can't challenge everything and you can't litigate everything. And so it becomes the type of a situation where the agencies can still push the views that they want, maybe through some of these less, an examination, matters requiring attention, whatever it may be. And, regulated entities are going to have to decide, when do you make a stand because something isn't within an agency's scope or you think they've gone too far. So, those are the types of things that, companies are going to struggle with in real time, just with their ongoing relationship with their regulators.
Agreed.
Liz, I didn't know if you had anything you wanted to add as well.
No, and I hesitate because I think you really summed it up nicely. I will often say there are things that I will advise in a counseling posture that that when you get into litigation, simply you don't have the luxury of saying, right? If we're already in a litigation posture and we need to fight, then we're going to make the arguments that we need to make. But that doesn't mean that one should run their business based on that, right? There are conservative approaches that we can still take. And I think it is important to maintain the relationship with your regulators so that you can have that insight, particularly now when everything is changing. I think Max kind of set me up to say this because we've had many heated discussions about language like that is bolded on the slide. The litigator in me thinks that this language is probably very vulnerable, at least with this particular Supreme Court. Now, whether a district court or a specific circuit is going to agree with me is up in the air. But I think that to the extent Congress wanted to impute deference using this particular phrase, I think that at some point in time, it's going to be deemed to have gone too far, that it doesn't have the type of principle or limitations that this court is going to want in terms of delegating authority. I think that you can cram way too much into the idea of what is proper in order to effectuate a statute, and particularly the CFPB, which has been, some people will say aggressive, some people will say they've been a little, they have policy goals and they're open about them and we need to follow them because they're going to go after them. But some of them really do push the limits of what most people would think the agency was created to do. And if you're trying to do it under this type of language, I think it's going to be vulnerable. But
so Liz, so when we look at language like this, and obviously, this is different because it's an older, right, statute. It predates, I think, Chevron. It's been updated, right, with the Bureau before that, but it's, this is at least this is a standing statute, right? Either there could be a new one tomorrow, right? But so how would provisions like this with the Skidmore decision in the background how do we, what are we to make of those two kind of competing polls?
No, I agree. I mean, look, Skidmore, the court can still say, I think the agency's position is persuasive, right? And what the court can't say is that the agency's position is okay, and I guess I have to go with it, right? Like, and so it's not so much that I think that this type of language is going to be struck because courts can't even consider the agency's judgment. They can. It's just, you can't use this type of language to shoehorn Chevron deference back into a court's analysis. And I think most courts are going to be smart enough to avoid that. I think what we're going to see a lot of is, the court has conducted its own analysis. The court has considered opinions from both sides, right? I don't think we're going to see courts trying to bring deference back using this language. I just think that necessary and proper are simply too broad to be a hole big enough to drive Chevron back through, right? And
that also brings up the weird kind of the kind of weird situation our deference has, right? For those that are interested, right? There's even a doctrine where an agency can interpret its own ambiguous regulations, right? Under our that's been cut back with Kissor a few years ago. That kind of seems like an outlier today, doesn't it, Liz? It wasn't addressed in the recent cases, but it's hard to square it, right, with Loper.
No, I totally agree. I would not want to be the attorney arguing for our deference.
Great.
All right. Well, we've been talking about kind of what happens on the back end, like how do you challenge all these rules and interpretations, but we haven't really talked about the actual promulgation of the rules themselves. So in light of these decisions, Max, how do we think the rulemaking process for a lot of these federal agencies may be impacted?
Sure, thanks. It's going to be different for every agency, of course, but at a very basic level, the APA, right, where Chevron didn't discuss the APA very much, now we are in the crosshairs of the APA. So expect a longer process, right? A very developed record, to avoid an arbitrary, kind of characterization of an agency action. I think we're going to see agencies really take pains to explain where they're getting their authority from, why they're doing what they're doing, the costs and benefits that they've considered, why they didn't go with alternatives. Right, you're going to see very robust note. I mean, we already see notice and comment very clearly, but I think, certain agencies, I think of the Fed, for instance, that is, doesn't really historically wanted to be in political crosshairs. They're still not going to want to be, right? It'll be interesting to see how more, kind of politically charged agencies, decide to do this. But I don't think any agency really wants to experience landmines in this space, because it's going to, all these challenges to rules are going to cause the rulemaking to just be very, very possibly just an elongated process. It's not clear. Even if the agency also wins, right, it might just take a lot more time. That can be good, I suppose, in some ways, right? It's possible that there's more moderate positions taken by the agencies, less pendulum swinging when new administrations come in for certain agencies. It probably is going to be more time intensive, cost intensive for the agencies, possibly less ambitious agendas. We don't know them. OMB has, can scrutinize agency actions. Congress can with the Congressional Review Act. All these things are going to happen even outside of the court in environment. So it is going to be, I think the upshot of a lot of this is that while industry may not have liked the way perhaps an agency decision was deferred to or presumed to be deferred to before, they may have had more certainty as to how to navigate. Maybe now there's less certainty. I'm sure they'll find a way to respond, but and make business decisions. But it's possible that there's going to be a lot more uncertainty, unclear rules of the road especially when looking at new products and services, new ways of doing things. It's possible that someone you don't even know about is going to challenge right under corner post, right? Could challenge something that you're predicating your whole business model on. It's going to be dynamic, I think, in that regard.
I think if I could just add, because Max brought up corner post, which I think is very appropriate at this point, I think we may also see less emphasis on actually completing the formal rulemaking process. Because recall that corner post, that statute of limitations is by the final action. And there are many ways for agencies to send messages without actually engaging in a final agency action. So we may see some creativity there as well.
I just wanted to jump in and say that I think that the SEC is already experiencing some of this with the challenges to their climate disclosure rules, and that's already going to be heard by the Eighth Circuit, and so we're already seeing it in play now. And with the climate rules were already under scrutiny. They went under public comment, and they were even changed based on the public's response to some of the proposals, and they're still challenges, right? And so I think that that's like a really good example of current versus what we think is going to happen. It's already happening for the SEC, at least in this one area.
And I think just to keep the conversation going on that point, you can look at an agency like the CFPB, and they've been very active in the past in just setting forth kind of notices about what they have concerns about, without necessarily going through a rulemaking process. And that's kind of a shot across the bow, where do you really want to risk that? And, they've also, in their back pocket, they've got their UDAP authority. They have supervision examination authority, as do the federal banking regulators. And so there's a lot of levers that they can use to kind of put pressure on and push kind of positions that they want industry to take without having to go through a formal rulemaking process that could be challenged, and just kind of relying on the fact that for most part, businesses don't want to get into litigation with the government and fight if they don't have to. And so I think you're probably going to see some of those more informal behind the scene things happening as well. We are getting very close to the end. I don't know if anybody has any kind of final thoughts about what we might expect from some of these agencies, or what to keep an eye on.
On the banking side, we know it's easy to say what has been announced, right? We know that the Basel Endgame, a litigation strategy has been published by the industry, even before the decision, the Loper came out. That doesn't mean there's going to be no capital rules, right? But it's possible now that there's a rethink by the Fed to avoid further litigation challenges, or even the hints of it. Fed master accounts, that's active in litigation. The Fed, that's a great ambiguous idea. Who can get a Fed master account? What kind of bank? What kind of charter? The acting comptroller of the currency has said that the OCC is going to revisit preemption interpretations. That's coming after Cantero and Loper. And just one anecdote on even something as simple as the FDIC digital sign issue. Everyone even agrees that needs to be modernized. The FDIC, has issued a rule. It's trying to update this, and it's rife with issues and interpretive questions. Industry has said we can't even comply with this right now, based on guidance we're getting. We need more specificity. It needs to be more clear. It needs to be less ambiguous. And that was, even for something that people agree on, it shows the pitfalls of this, and using, stilted language, perhaps even trying to be more specific can still come at a cost of further questions for industry. So it's gonna be a challenge, I think, for some of these kind of easy low-hanging fruit.
Any closing thoughts, Adrienne, from the SEC, or Liz from the FTC perspective?
I just think for the SEC, again, like focusing on exam priorities and looking over the next couple of years at the enforcement reports to see if there's a change in the direction and types of cases that are being brought. And I think that will help guide us on this side on how to proceed before the SEC.
I think we're going to still see a focus on fees and deceptive practices. I think that both the CFPB and the FTC are just going to change the approach of how they put those policies into action.
Great. All right. Well, I think we are at time. We were able to answer at least one question, I think, but hopefully we're able to capture and cover all the things that the audience was interested in. Just as a reminder, the code for today for the CLE was Agency 2024. All one word, Agency 2024. And so with that, thank you to the audience, and thank you to all my Venable colleagues for a great discussion this afternoon.